I'm Jacob Hornberger, president of the Future of Freedom Foundation, and it's an honor to be here at the Students for Liberty Conference. We've lined up what we call a conference within a conference. This is our third year here, and this year we decided to put a whole program of lectures on this theme of civil liberties and the national security state. And as many of you know, FFF has long taken a very principled, uncompromising approach to libertarianism. Half of what we do is addressing economic issues, but the other half, since our inception, but especially since 9/11, is addressing the vital importance, the critical importance of civil liberties and the role of the national security state plays in infringing and really destroying civil liberties. And so we thought, well, we're going to come to the Students for Liberty Conference and we're going to raise students' visions and other people's visions to the critical importance of these issues. We happen to believe that the warfare state poses a much graver threat than anything else to the freedom and well-being of the American people. And so what we decided to do this year, in previous years we had a conservative join us on a panel who was very principled in civil liberties. That was Bruce Fine. And this year we said, let's mix it up a little bit and have some people from the left. But only those people who have retained a consistent position with respect to civil liberties in view of what the Obama administration has done. And we know many of the progressives have just caved. But among those who have not caved are people like our speaker today, Jameel Jaffer. He works for the ACLU. He's a litigator there. He's a trial attorney. And the ACLU has been just doing fantastic work consistently in the area of civil liberties and of course the drug wars, many of you know. I mean, they have been one of the stalwart voices both in the Bush administration and then continuing in the Obama administration, which of course continued everything that Bush was doing. Jameel is the author of a book called Administration of Justice. He litigated the first successful challenge of the Patriot Act. He's a human rights monitor at Guantanamo. He's one of the leading figures at the ACLU in battling against much of the war on terrorism stuff, the dark side stuff that the Obama administration is engaged in. He's a graduate of Harvard Law School. Please welcome Jameel Jaffer.
Thanks very much, and thank you to FFF for inviting me. Just one excuse before I begin. I just got off a flight from London about an hour ago, so I'm still kind of in a daze. And if I keel over, that's why. So 2 years ago, before the Snowden revelations hit the newspapers, I litigated this challenge to the constitutionality of a 2008 law that pretty dramatically expanded the government's authority to monitor Americans' international communications. Can you guys hear me at the back? Speak up? All right. I represented a coalition of media and labor and legal organizations that were concerned that the government would use this law, the FISA Amendments Act, to engage in dragnet surveillance of their phone calls. But rather than defend the law in court, the government argued that my clients just didn't have the right to challenge it. The government said that my clients couldn't prove that their communications would be swept up in this law, and because they couldn't prove that their communications would be swept up, they didn't have the right to challenge the law. Now, many people, myself included, thought that there was something perverse about that argument, but in a 5-4 decision, the Supreme Court endorsed it last year. And writing for the majority, Justice Alito held that the only people who can challenge government surveillance, the only people who can challenge the constitutionality of government surveillance are those who can show that their communications have been monitored. And it didn't seem to trouble the court that government secrecy might prevent anyone from being able to make that showing. Justice Alito also didn't buy the idea that the NSA was engaged in dragnet surveillance or widespread surveillance of Americans. My client's contention that the NSA would use this new law to sweep up their communications was, in his words, speculative and conjectural. So now we're a year later, and it's hard not to wonder whether Justice Alito would say the same things if he had to write this opinion today. Thanks to Edward Snowden, we now know for a fact that the NSA is engaged in large-scale surveillance of Americans' international communications and in general of their communications. The NSA is sometimes described as a foreign intelligence agency, but we know that much of the agency's energy is dedicated to collecting information about United States citizens inside the United States. And the NSA's director, Keith Alexander, acknowledged that the agency's aim is to collect it all. That was his phrase, collect it all. Those are his words. The agency's aim is to know everything that there is to know. And actually, the agency has made considerable progress towards that goal. Under one program that I'm sure you are all now familiar with, the NSA collects information, so-called metadata, about every single phone call that you make. You pick up the phone, you call your mother, you call your friend, you call your doctor. The NSA has a record of it. The NSA makes a note of who you called, when you called them, and how long you spoke. And they've been doing that for 7 years, and they want to do it indefinitely. The NSA assures us that this is only metadata, that the government doesn't listen to the content of phone calls. But metadata can, in many contexts, be more revealing than the content of your communications. By studying your call records, the government can learn whether you have contacted a substance abuse counselor. They can learn whether you called Planned Parenthood. They can learn whether you've called the Federalist Society. They can learn whether you've called an oncologist. It can learn your political views, your religious views, your medical history. It can learn about the rise and fall of your intimate relationships. There's a whole lot that the government can learn from metadata, from information about your communications, even if it never listens to the communications, never listens to your phone calls, and never reads your emails. So that's the call records program. There's another program which has received somewhat less attention in the press, under which the NSA is scanning international communications for keywords. Every email into and out of the United States is scanned for keywords. Communications that contain information that's of interest to the NSA are stored in these massive databases for later analysis. And in fact, the databases are so vast that the NSA no longer has space to house them. You may have read that the NSA is building a new data center in Bluffdale, Utah. And that data center is so big that it requires the same amount of electricity as it requires to heat 33,000 homes. That tells you something about how much data that they're storing there. Recently, the NSA introduced a new surveillance program that's directed at its own employees. And I bring that up because I have a 2-year-old son, and the other day I was reading him a Shel Silverstein poem called Hungry Mungry. Maybe you know it. It's the story of a kid who's so hungry that he eats not only his dinner, but the cutlery and the kitchen table, the U.S. Army, the mountains, the seas, and eventually the entire solar system. And eventually there's nothing left to eat except himself. And at the end of the poem, he just sits there gnashing his teeth. And the last line of the poem is, because there was nothing, was nothing, was nothing, was nothing, was nothing was left to eat. And I think that the application of this very profound poem to the present topic is obvious. The NSA's appetite for information about our communications and our activities, online as well as offline, seems to be boundless. So, should this trouble us? Don't we want our intelligence agencies to be able to identify threats before they arise? Don't we want them to be able to connect the dots, so to speak? And if we want them to connect the dots, should we complain when they say we need to collect all of the dots first? If you've been paying attention to the surveillance debate over the last few months, you've probably heard government officials making those arguments. According to the standard defense of the NSA's activities, the agency's activities are effective, they're closely supervised, and they're lawful. Now, in the next few minutes, I want to try to persuade you, or at least start to persuade you, that none of those things is true. The truth is that we have let the NSA slip its chains. The truth is that the NSA, which was meant to be a guarantor of our collective security, has become a danger to it instead. So the argument to the contrary has three parts, and I'll address each of them in turn. First, is the NSA closely supervised? To the extent that the NSA is supervised, it's supervised by the Congressional Intelligence Committees and by something called the Foreign Intelligence Surveillance Court, or the FISA court. The trouble with the intelligence committees is that they've been entirely captured by the agencies that they're meant to oversee. They've actively impeded the rest of Congress from even learning about the NSA's activities, at one point going as far as to withhold from the rest of Congress documents that even the White House was willing to share. The committees failed to object when the NSA redefined key legal terms to justify a secret expansion of its surveillance power, and it failed to object or to correct the record when intelligence officials lied to the public about the NSA's activities. When the Director of National Intelligence, James Clapper, testified to Congress that the NSA wasn't collecting information about millions of Americans, no one on the intelligence committees bothered to tell the public that Mr. Clapper's statement was false. Now, there are a few members of the intelligence committees, especially of the Senate Intelligence Committee, who did object to the NSA's activities, and I think that Senators Wyden and Udall and Heinrich deserve credit for the efforts that they made. But in the end, those efforts were unsuccessful. We learned about the NSA's surveillance dragnets not from the intelligence committees and not from members of the intelligence committees, but instead from Edward Snowden, from the Washington Post and the Guardian. So that's to say that the intelligence committees have been very effective at giving the NSA or giving the NSA's activities a semblance of legitimacy, but they've been spectacularly ineffective at ensuring that the activities are in fact legitimate. The court that oversees the NSA has proved to be an equally weak check against abuse. The court, as you may know, meets in secret. It allows only the government to appear before it, and it rarely publishes its decisions. Since its creation, the court has considered about 30,000 surveillance applications, and of those it has denied only a handful. You can count them on two hands, the number that it's denied. So given that, it's perhaps not surprising that the court was a full participant in designing the surveillance programs that we've recently learned about. It allowed the NSA to use a relatively narrow provision of the USA Patriot Act to launch the largest electronic surveillance operation ever launched by a democratic government against its own citizens. It reauthorized the operation over and over again, even after the NSA repeatedly violated the rules that the court had set for it. So I think it's grossly inaccurate to say what intelligence officials have been saying, that is that the NSA is closely supervised. It's not. The intelligence committees and the FISA court give the NSA surveillance activities a veneer of legitimacy, but it's only a veneer. So that's the first argument about supervision of the NSA. The second argument that intelligence officials make is that the NSA's activities are lawful. In my view, much of the surveillance that we've learned about over the last few months is illegal. The activity has been allowed to persist only because government secrecy has insulated it from meaningful legal challenge. Consider, for example, the phone records program, the metadata program. The government's argument is that that program is authorized by the Patriot Act and consistent with the Fourth Amendment. One problem for the government, though, is that the legislator who wrote the act says he had no intention of authorizing a dragnet on that scale. Another problem is that to accept that the government can conduct dragnet surveillance under that statute is to accept that it can conduct it under many other statutes as well, because those other statutes use exactly the same language that the Patriot Act does. There are dozens of statutes that allow the government to collect information that is relevant to an ongoing investigation. And if you interpret the word relevant as the government has done it under the Patriot Act, there's no reason why relevance shouldn't or couldn't be given the same meaning under all those other statutes. And so once you have opened up this particular door, you're opening up a lot of other doors as well. Still another problem with the government's theory is that to accept that the government can collect phone records in this kind of dragnet is to accept that it can lawfully collect all kinds of other records as well, bank records, for example, or medical records, or location records. If call records are accessible under this law, why can't the government vacuum up all of our location records as well? I hope you all know that your cell phones track every move you make, right? All of that location information is stored by the telecommunications companies, and the government's theory is that all of that information in the hands of the telecommunications companies is accessible to the NSA as well. Not just accessible, but accessible without an individualized court order, without a showing of individualized suspicion, accessible on this relevant standard that the Patriot Act imposes. So accepting the government's legal theory requires accepting that an altogether unremarkable phrase relevant to an ongoing investigation in an innocuous statutory provision gave the NSA the authority to put every single American under permanent surveillance. That's really their theory. That is their theory of the law. So to say that the NSA's surveillance activities are on firm legal footing is, in my view, nonsense. The NSA's authorities have survived because they've been secret, because they've used those authorities in secret. Only now, for the first time, are these authorities being challenged. By the way, you don't have to take my word for the fact that these authorities that many of these activities are unlawful. A review board appointed by the president himself concluded that the metadata program should be shut down. Before Christmas, a federal judge here in DC reached the same conclusion, holding that the program was unconstitutional. Just a few weeks ago, the PCLOB, the Privacy and Civil Liberties Oversight Board, concluded that the program wasn't even authorized by statutory law. In other words, wasn't even authorized by the Patriot Act, let alone, they didn't even need to reach the constitutional question because they found that it wasn't authorized by statute. So I think that it's fair to say that there's a growing consensus that, that at least some of the activities that were disclosed, that have been disclosed over the last few months, are unlawful. And I think that what we will see over the next few months is more and more challenges to these previously secret programs, and some of those challenges will certainly be successful. So that was the second argument, that the NSA's activities are lawful. And the third and final argument that the government has been making, and I'm not going to talk for too long because I'd like to just open it up for questions. But this third and final argument that the government has been making is that the NSA's activities, whatever you may think of the supervision of the NSA, whatever you may think of the lawfulness of these activities are necessary. These activities are effective. These activities are protecting us from very real threats. So let me just tell you one story about secrecy. When the government first proposed the call records program to the FISA court, when it first went to the secret court and said, we want to do this dragnet surveillance of the entire country, we want to collect information about every phone call, what it said to the secret court was that the call records dragnet was, quote, the only effective means of tracking the associations of suspected terrorists, the only effective means. And on the basis of that representation, the court authorized the program in 2006, and it reauthorized the program over and over again after that. Now, after Edward Snowden exposed the program in last June, the ACLU challenged the constitutionality of it in an ordinary federal court, not a secret court, but an open court. And shockingly, the representation that the government had been willing to make before the secret court, the representation that the program was the only effective means of tracking the associations of suspected terrorists, it wasn't willing to make in the open court, a court in which its assertion would have been challenged and subject to examination. Instead, the government said something much weaker. It said that the call records program was one tool by which it tracked the associations of suspected terrorists. Now, perhaps that doesn't seem like a big deal to you, the difference between one tool and the only effective means. But in a court of law, I think that the difference between those two things is quite vast. And I think it's a good example of the corrupting influence of secrecy. The government said things in secret that it was unable to defend and unwilling to defend in public. And those things that it was unwilling to defend were crucial things. They were pivotal things. It was the central claim about the effectiveness of the program. It was the claim that the secret court had relied on in order to justify authorizing the program in the first place. And that was a claim that the government was unwilling to repeat in open court. So now, as it turns out, the call records dragnet doesn't seem to be very effective at all. Asked to explain the effectiveness of the program, the NSA first alluded to 50 or so cases in which the call tracking program was purportedly critical to foiling a terrorist plot. Over time, though, it slowly backed away from that claim, and now it relies principally on a single case in which the call records program is said to have allowed the government to identify someone who sent several $1,000s to Somalia. I think that's worth thinking about. There's some question of how relevant the call tracking dragnet actually was to the Somalia case, but let's assume for a minute that the call tracking program was absolutely critical to it, that but for the call tracking program, we would not have been able to identify this guy who sent money to Somalia in violation of the material support laws. Now, do you think that the Somalia case can possibly justify a 7-year-long dragnet of Americans' telephone records? To say that there's a disconnect between the effectiveness of the surveillance on the one hand and the invasiveness of the surveillance on the other, I think is a dramatic understatement. The government has not been able to point to the kind of evidence that you would need to see in order to even remotely begin justifying a program of surveillance on this scale. I don't want to say much more than that, but I do want to reiterate one point about the implications of all of this surveillance. The surveillance is, again, said to be necessary for national security reasons. But few things pose a greater threat to our long-term security than an intelligence agency that recognizes no limit on its authority to collect information about us. It's not just the invasion of privacy, though the invasion of privacy is obviously no small thing. It's also the threat. It's also that the threat of surveillance chills lawful speech and association. It discourages citizens from engaging in the kinds of activities that are necessary to any open society. And to see that, you need only look at the example set by the societies that experimented with pervasive surveillance during the Cold War. I'm not drawing an equivalence between those societies and ours. I'm not saying that the United States now is facing precisely the same issues that East Germany was after World War II. It's not. But surely there's something we can learn from the experience of those countries. And surely we should be thinking of those societies not as an example, but as a caution. And if you look at the defense that the government is making for many of the surveillance activities that have been exposed over the last 6 months, I think it's entirely reasonable to fear that we're going in the wrong direction rather than the right one. So I'll leave it there and happy to open it up for questions or criticisms or complaints or whatever you may have. I think you have to come up to the mic if you have.
Hi, I don't know if this is on or not. I just wondered if you think it's even fair to call the FISA court a court. That's my question. Thank you for asking that. I was going to ask.
Isn't it, in fact, a calculated lie? I just wanted to add to it.
Yeah, you know, I actually feel better about the FISA court now than I did 6 months ago. I still don't feel great about it. I think that the FISA court, that there were junctures over the last 10 years at which the FISA court did subject the government's claims to real scrutiny, drew lines around some of the surveillance activities that the government was engaged in. And to be entirely honest, I didn't entirely expect that. I didn't expect to see that in the court's decisions. On the other hand, there were many junctures at which the court did what I mentioned earlier. It reapproved programs even after the NSA had repeatedly violated rules that the court had set. And I think that there is one strand of criticism of the court that focuses on the personalities of the court and on the sort of culture, the culture within the court that is overly deferential to the government. And I'm not saying that those criticisms are entirely unfair. I'm sure that they're not entirely unfair. But to me, the bigger problem is a structural one. The court isn't set up to be a check on government surveillance, right? The court, as I said earlier, it meets in secret. It hears only from the government. It rarely publishes its decisions, and with that kind of structure, the court can't realistically be a check on government abuse. And one of the things that you see if you look at the opinions that were drafted over the last few years, you see in a number of cases the court address civil liberties arguments that the government presumably brought to its attention, but not address other obvious civil liberties arguments that the government failed to bring to the court's attention. This is a little bit weedy, but there's a strong argument that there's a statute that forecloses the government from collecting call records under the provision that the government is relying on to collect call records. And the government didn't bring the court's attention to that other statute until 3 years after the program had been launched. And even when it brought the issue to the court's attention, it brought the issue to the court's attention in such a way as to suggest that the issue was a minor one that could be addressed with a minor change to the court's reasoning, when in fact it's a huge hurdle to the kind of surveillance that the government is engaged in. And when we brought our challenge to the call records program in June, we relied heavily on this argument that the court had never really had an opportunity to address before, or had never addressed before, because the government hadn't adequately brought it to its attention. That's a long answer, but all I'm trying to say is that I think that the problem is less the people on the court. It's less the culture of deference, although that is a problem. The problem is mainly the fact that the court is deciding these issues with far-reaching implications for individual rights in a process that's not adversarial.
And do you know enough about what Edward Snowden actually did to be able to comment on the legality of what he did, and maybe within the context of whistleblower laws? Is that something you can comment on or give an opinion on?
I can't say much about that case because we represent Edward Snowden, and but what I will say is that the whistleblower laws would not have protected him. The whistleblower laws in general have an exception for the national security community. It's a little more complicated than that, but essentially that's the problem. And so people who want to report abuse or fraud within the intelligence community don't have many options. And then you also have to remember that the institutions that somebody inside the government might otherwise go to report the kinds of abuses that have been exposed over the last 6 months, those institutions had approved these abuses, right? The FISA court, the intelligence committees. So who do you go to? I think that a basic principle of First Amendment law is that speech about government misconduct is at the core of First Amendment protection, and this is an issue that hasn't been directly tested in recent whistleblower cases, but in one of these cases soon it'll be tested, and the courts will have to decide how much protection the First Amendment gives people who are speaking the truth about government policy with an intent, not with the intent to harm the government or to harm the country, but quite the opposite, with the public interest at heart.
Are you concerned that the NSA's tactics are seeping into other law enforcement agencies? Because I remember reading about a few states where police precincts were taking phone records and using them without warrants to try and track down criminals, and these weren't necessarily, they weren't suspects yet. They were just searching. Is that, getting out of hand?
Yeah, that's actually a really good question. There are two ways. There are two things going on that I find disturbing. One is local law enforcement agencies are now using many of the same surveillance tools that the NSA uses. It doesn't require sophisticated technology to gather phone records, and many local law enforcement agencies gather those records without a warrant, and without individualized, often without individualized suspicion. So, one concern is that the Fourth Amendment and statutory law have not kept up with technological change, and the result is that law enforcement officials at the state and local level have many more surveillance authorities at their disposal and are using them very aggressively. So that's one concern. And then there's a distinct concern about the way that the NSA's surveillance seeps into the work of other agencies. So the NSA gathers all this information. It doesn't just sit with the NSA. The NSA then shares it with the Justice Department, or it shares it with the DEA. It shares it with, there's a story in the New York Times today that it just went online about an hour ago that suggests that they shared some of this information with the Department of Agriculture. So everybody gets this, everybody gets some piece of the NSA's information. And then your rights can be affected by that information that the NSA has shared. You may be put on the no-fly list, for example, on the basis of information that the NSA has shared with the FBI. And you may never know that that's where the information came from. You may never know until you show up at the airport that you're on the no-fly list. And then when you are told, I'm sorry, sir, you can't get on the plane, you'll go home and you'll write a letter to the Department of Homeland Security, and many weeks later you will get a one-page form letter back that says, thank you for your letter, we have examined our files, and to the extent any changes were deemed to be necessary, we have made those changes. Signed. And then you can go back to the airport and try again. And you will never know that it was the NSA's surveillance activities that led to that information being provided to the DHS, and you will never, or the FBI, and you'll never have an opportunity to contest that evidence if it's evidence against you. You will never even be provided notice of the reasons for which you were placed on the list. And then this information is also shared with the Justice Department, and the Justice Department brings criminal prosecutions on the basis of this evidence. And I mentioned this case that we litigated in the Supreme Court last year, or 2 years ago, which was a challenge to the FISA Amendments Act, this 2008 law that authorizes warrantless wiretapping of international communications. And the government made that argument that I described earlier, the argument that you can't challenge this law because you can't show that your own communications were monitored under it. And we said to the court, if you accept that argument, then nobody will be able to challenge this law because nobody will be able to show that their communications were monitored. And the government said, no, that's not true, because if we prosecute somebody based on evidence obtained under this law, we will give them notice that that they're being prosecuted with evidence obtained under the law, and they will have the opportunity then to contest the lawfulness of the surveillance. We learned only recently that the government didn't have a policy of providing notice to criminal defendants. Quite the opposite. The government's policy was to conceal the role that NSA surveillance had played in those criminal prosecutions. So for 5 years, people were being prosecuted on the basis of evidence derived from this law, and the government wasn't telling them that that's where the evidence was coming from. So there are people who are now in prison who should have had an opportunity to say, the surveillance you conducted of me was unlawful, and the fruits of that surveillance should have been suppressed, and my conviction is improper because it was based on the fruits of unconstitutional surveillance. So this question of, again, this is a very long answer to a question I probably could have answered in a sentence, but this question of how the NSA's activities, how the NSA's surveillance seeps into the work of other agencies, I think is a really important one, and not one that we have really struggled with until recently, because until recently it was all hidden from us, and only recently have we started to learn the ways in which this information is being used by other agencies.
First of all, thanks for the talk. And just a quick question. So as I saw in a lot of the mainstream media, a lot of the phone dragnet has been focused on. But as our communications as a society and a world move away from analog or digital voice communication onto the internet, do you have any hope for prosecuting those kind of surveillance as well as, instead of just the call? Because honestly, me and most of my friends, probably use our phones like 10 times a month. So we don't really concern about that, but our locations on our phones, like you said, is huge. So.
Yes, no, absolutely. So the phone records dragnet that I spent most of my time talking about is only one of many of the programs that have been disclosed over the last few months, and a lot of the other programs are not focused on telephone calls or call records, but rather on email or text or even taking information from your address book. Some of these programs aren't directly about gathering information. Some of what the NSA is doing is just, some of its efforts go towards compromising the security of your communications so that if they ever want to get them, they can get them more easily, right? So there's this whole set of issues that that I think organizations like the ACLU are only now just catching up on. But you're right that there are all sorts of ways we communicate now that don't involve the telephone. And in some ways, it may be that the most troubling of these surveillance programs are the ones that don't involve communications at all, but involve things like location. Because the NSA, does have this massive location database now. It's still unclear to what extent Americans' locations are in that database. Certainly they are. Some Americans' location information is in there. But we don't know the scale of the American aspect of that database. But it is, more generally, this vast database of location information that allows the NSA to determine not just where you were at any particular time, but who you were meeting with, right? Who you were walking with in Central Park, or who you saw when you went to London, or there are all sorts of conclusions that the NSA can reasonably or unreasonably draw from the intersection of various people's location information.
Hi, I'm Dave Casper with Empowerment Project. We've been working on a documentary, part of which deals with government surveillance, and the big controversy about the metadata collection program. One of the things they always tell us is that, oh, it's just metadata, it's not content. But we've heard otherwise from people, that they actually are capturing content of phone conversations. We've heard this from Bill Binney, from Russell Tice, and I want to know more about that. What do you know about?
They're certainly collecting content. This phrase that has become very popular with the intelligence community over the last few months is the phrase "under this program," right? Because they say they'll be asked, are you or are you not collecting content? And they'll say, "Of course, we're not collecting content under this program." And but we know for a fact that they're collecting content under other programs, under the FISA Amendments Act, under this 2008 law. They collect content. That's what that law is all about. There is this separate call records program that is focused solely on metadata, but that is just one of the one of many programs.
And one of the things that Bill Binney said is that a big reason for constructing the big data centers like the one in Utah is so that they will have the storage capability to actually store all of the content. He said if they didn't need to do that, they wouldn't need all of that storage.
Right. Yeah, I think that's right. I mean, my understanding of the way that the content dragnet works right now, this is mainly from a Charlie Savage article in the New York Times a couple months ago, is that they copy every text message, whether it's an email or a text message, anything that's text-based, they copy it momentarily. During that moment in which they have a copy of everything, they search it for keywords, and the hits are then stored. But there are enough hits that they need these massive databases to store, just the filtered messages, and that's what places like Bluffdale are for. And then they store them for long periods of time. There are minimization procedures that were leaked in June that suggest that they store that even things that don't include foreign intelligence information, which is the phrase they use to describe their mandate, really, even communications that don't include that kind of information can be stored for up to 5 years. And foreign intelligence information can be stored indefinitely. And foreign intelligence information is defined broadly enough that if you're having a conversation with somebody about the elections in England, that's foreign intelligence information. If you are a lawyer representing a client who has been accused of a national security related crime, that's foreign intelligence information. It's a broad. If you're a human rights researcher and you're looking into human rights abuses in Syria or Colombia or anywhere, that's foreign intelligence information. So there's a lot that they can store as foreign intelligence information, and once it's foreign intelligence information, they can store it forever.
Thanks.
Is there any legal ambiguity about using anti-surveillance technology, like encrypting your phone, protecting your computer? Are you putting yourself at risk by actively trying to deny the NSA's ability to monitor you?
I don't think you're putting yourself at any legal risk by doing that. There is a theory that by taking unusual measures to protect your communications, you signal to the NSA that there's something you want to protect. I don't know if that's true or not, but it's something that some people say. Is Julian Sanchez here? He may have a better answer to that question. He was here earlier, but he may have left.
I could channel my inner Bruce Schneider and say, Bruce says that if all of us encrypt, then we get rid of the problem.
That's right.
The problem is
Yeah.
called encryption
Yeah.
for the regular user.
Did everybody hear that? No. If we all encrypt, then we don't have that problem, right? Yeah.
Hi, one thing
I think this has to be the last question.
okay. One thing that isn't clear to me in the reporting is the sharing that goes on among Five Eyes. So could the NSA get around the ability to collect on Americans by having Britain collect it, and then they share it with us, and then they technically don't collect? Because I think that we share with our partners as well.
They certainly do that to a degree, but part of the Five Eyes agreement, as I understand it, is that we collectively agree not to surveil our own citizens except in the following circumstances, which includes, the U.S. surveilling French citizens. But then you see these reports that suggest that the U.S. is engaged in dragnet surveillance in France, and it's hard to square that with the reports about the agreement, the Five Eyes agreement. So I don't have a good answer to that question. I think the most detailed story that's come out on that particular topic over the last 6 months is a story, I think it was in The Guardian, about sharing with Israel, and they actually produced some of the documents that were behind that sharing. But I'm not sure that actually answered any questions rather than just raised them. I think I have to leave it there, but thank you all for showing up.